Hello everyone, welcome to another edition of Legal Podcast powered by IndiaLaw LLP. I am Ishika Soni and today I am discussing a landmark Supreme Court judgment that brings much needed clarity to one of the most sensitive areas of service law, that is post-retirement disciplinary action and the protection of retiral benefits. This judgment is especially important for the employees of public sector undertakings, statutory corporations and disciplinary authorities, because it answers a very crucial questions. That is, can an employer, after an employee has retired, suddenly wake up, initiate the disciplinary proceedings withhold the gratuity and recover the alleged losses when the service regulations themselves do not expressly permit it? The Supreme Court answered this question with a very clear, reasoned and emphatic no. In service jurisprudence, retirement is intended to mark a point of finality. Ordinarily, once an employee superannuates, the employer's disciplinary control comes to an end. Retiral benefits such as gratuity, provident fund, and leave encashments are not acts of charity. They are recognized as property under Article 300A of the Constitution of India, and any interference with them must be firmly rooted in a very clear and express statutory provisions. And in doing so, it reaffirmed a fundamental principle of service jurisprudence. That is, retirement is not a comma, it is a full stop. No person shall be deprived of his property save by an authority of law. This means one thing very clearly: no authority, no law, no deprivation. It is against the settled legal background that the facts of the present case must be understood. In the case of Mr. Kadir Khan Ahmed Khan Pathan, Mr. Kadir Khan Ahmed Khan Pathan joined the Maharashtra State Warehousing Corporation on 4th of January 1969. After nearly 4 decades of the service, he retired as a storage superintendent in 2008. On the date of his superannuation, there was no disciplinary inquiry pending against him. He was not under any suspension, no charges has been framed, and no financial losses had been attributed to him. For all these practical legal purposes, his service stood concluded. However, 11 months after his retirement, on 18th of August 2009, the corporation issued a show cause notice alleging that during his tenure as center head, he was responsible for storage losses amounting to Rs 22.22 lakhs and railway transit losses of Rs 15.20 lakhs. This was followed by the issuance of charge sheet under Regulation 741 Clause 5 and 742 Clause 13 of Maharashtra State Warehousing Corporation Staff Services Regulations 1992. Mr. Pathan sought access to some of the documents also which were necessary to defend himself, but those documents were never being supplied to him. And despite this, the inquiry proceeded ex parte, culminating in a second show cause notice dated 9th of November 2012. By an order dated 10 December 2012 further, the disciplinary authority held him responsible for a loss of Rs 18,09,809 and appropriated his retiral benefits amounting to Rs something around 4 lakhs. But the matter did not end there. In 2016, a further notice was issued seeking the recovery of a remaining amount. And finally, by an order dated 4th March 2017, recovery of Rs 13.66 lakh was directed. All of this occurred years after the employee had retired. Aggrieved Mr. Pathan challenged the entire disciplinary action before the Aurangabad bench of the Bombay High Court by filing a writ petition. And by this judgment, the High Court declined to interfere on merits. The High Court accepted the corporation's contention that the Rule 110 of 1992 MSWC regulations enabled reliance on Rule 27 of the Maharashtra Civil Service Pension Rules 1982. And held that while other retiral dues could not be withheld, gratuity could be. The High Court also granted liberty to the petitioners to pursue internal appellate remedies. Talking about the statutory rules, Rule 110 is a residuary provisions. It broadly states that in the matters which are not expressly provided for, the corporation may be guided by the government rules, subject to the suitability and adoption. Further, Rule 27 of the Maharashtra Civil Service Pension Rules 1982 states that the state government reserves the right to withhold or withdraw the pension or any part of it either permanently or for a specified period, and to order recovery from pension if the pensioner is found guilty of grave misconduct or the negligence during the service, including misconduct discovered after retirement. This power vests only in the government, not automatically in the corporations or authorities unless lawfully being adopted, but subject to the sanction by the state government. It states that disciplinary proceedings can be instituted after the retirement only if strict conditions are satisfied, and such proceedings shall not be instituted save with the prior sanction of the government according to Rule 27, Clause 2, Subclause B, Clause 1, that states the prior government sanction as mandatory. This means prior sanction is a condition precedent. Without it, the entire proceedings is without the jurisdiction, and subsequent approvals or implied consent is not permitted. But aggrieved Kadir Khan with the High Court's ruling appealed in Supreme Court. Before the Supreme Court, Mr. Pathan contended that the corporation never possessed the jurisdiction to initiate the post-retirement disciplinary proceedings. The 1992 MSWC regulations, it was argued, contain no enabling provisions which permit such action, and Rule 110, far from conferring power, is merely a residuary gap-filling clause and cannot be used to create substantive disciplinary authority. It was also further submitted by Kadir Khan Ahmed that even assuming Rule 27 of the Maharashtra Civil Services Pension Rules 1982 to be applied, Rule 27 Clause 2, Clause B, Clause 1 makes prior sanction of the state government a mandatory condition precedent for instituting the proceedings after retirement. That is, a condition that was admittedly never being fulfilled in the present case. The action was also being assailed as violative of natural justice and the property rights inherent in the retiral benefits. The corporation, on the other hand, defended its action by relying on past practices. It also argued that Rule 110 permits adoption of common service rules in areas where the MSWC regulations are silent. According to the corporation, approval which is granted by the Corporation and Textiles Department in 1990 to the regulations amounted to an implied, in this case, continuing the sanction for recourse to Rule 27 of the pension rules. But the corporation also invoked the doctrine of approbate and reprobate, pointing out that the employee had accepted a partial refund of certain non-gratuity benefits at a later stage. The Supreme Court undertook a very detailed examination of the statutory framework by stating that Rule 110 of the MSWC regulations was interpreted as a benevolent gap-filling provisions intended to regulate administrative matters not expressly covered but not as a source of plenary disciplinary power. The court also emphasized that for the government service rules to be applied, there must be a very conscious documented decision by the corporation's board of directors adopting those rules, which means something entirely absent in the present case. The court then examined Rule number 27 of Maharashtra Civil Services Pension Rules 1982 and particularly Rule 27 Clause 2 Subclause B Clause 1, which categorically provides that where disciplinary proceedings are instituted after the retirement, they shall not be instituted save with the sanction of the government. The court held that this language is mandatory and protective in nature and cannot be diluted or bypassed by relying on one-time omnibus approval which is granted decades earlier. In reaching this conclusion, the Supreme Court reaffirmed some settled precedents also, including Bhagirathi Jena versus Board of Directors, OSFC, Anand R. Kulkarni versus YP Education Society, and Girijan Cooperative Corporation versus K. Satyanarayan Rao, and all of which underscores that in the absence of the explicit statutory authority, post-retirement disciplinary proceedings are impermissible, and retiral benefits cannot be withheld or tinkered with. The bench comprising Justice J.K. Maheshwari and Justice Vijay Bishnoi also noted that the alleged misconduct related to events more than 4 years prior to the initiation of proceedings, further compounding the illegality. Since the inquiry itself has commenced without any jurisdiction in hand, every subsequent step taken, including withholding of the gratuity and recovery of amounts, stood vitiated. As the court effectively made very clear, if the foundation is illegal, the entire structure built upon it must collapse. And accordingly, the Supreme Court allowed the appeal, set aside the judgment of the High Court, and quashed the disciplinary proceedings in their entirety. The corporation was also directed to release all the retiral benefits, including gratuity, provident fund, and leave encashments, along with interest within 8 weeks, and to refund any amounts already being recovered. But the real importance of this judgment lies beyond the facts in three major points. First, It reinforces a very fundamental principle that accountability must be enforced during service, not resurrected after retirement. And second, administrative convenience cannot override the statutory safeguards. And at last, the retiral benefits cannot be converted into tools of coercion. For employees and the retirees, this judgment sends a very powerful message that retirement does not dilute your legal protection. And if an employer seeks to act after retirement, the law demands that there should be a very clear statutory authority. There should be a mandatory government sanction where prescribed or not. And thirdly, and strict compliance with natural justice must be there. And anything short of this will not survive the judicial scrutiny. Further, to conclude, the post-retirement disciplinary action sits at the intersection of service law, constitutional protection, and the administrative fairness. The Supreme Court has once again in the present case reminded us that power without the authority is no power at all. And retiral benefits are sacrosanct legal rights, not open-ended instruments of recovery. Thank you for tuning into the legal podcast powered by IndiaLaw LLP. Stay informed and stay compliant. I'll see you in the next episode.